Okay. So this morning we're going to discuss how to take title to property and having that discussion with your buyer as to how do you want to take title to the property and all of the different options that you have, which is an important conversation to have in advance of getting to the closing table. It really is important for you to know uh, what type of deed your client is interested in taking. So, title vesting, as it's called in legal terms, is what happens to the property after your death? Who profits from the home sale after your death? Who gets tax benefits if the co-owner dies? Who can avoid probate? So those, when somebody is taking title to the property as individuals, these are questions that you need to ask. In most states, if you are a married couple, the law presumes that you are taking title as tenants by the entirety. Up until 10 years ago, when the Supreme Court ruled that gay marriage needed to be legal in every state and recognized in every state, partners who were taking title in a state that didn't recognize a legal marriage really had to have this hard conversation. Do we want to take as tenants, joint tenants with the right or survivorship, which is the form of title that most closely resembles tenants by the entirety? Do we want to be tenants in common? Is it a common law state? How is that dealt with if you're not legally married? So all of those questions are questions that need to be asked ahead of time, and you need to have that question. What happens afterwards? When you just sell property, it's also an important to know how you took title to see who gets the proceeds from the sale. So while this slide mostly deals with what happens when you die, how you vested title also is very important when you go to sell your property. So you really need to know who your buyer is. Is the buyer an entity? Is it a trust or an individual? Those are basically the three types of individuals, entities, trusts, the things that can take title to property that are legally allowed to hold property. So if your buyer is an entity, meaning is it an LLC, a partnership, or a corporation, it's very important that you have the agreement of sale with the correct entity. So if Mr. and Mrs. Smith buy a property and then we get to the closing table and they've got the agreement of sale and it's Mr. and Mrs. Smith, and then they say, oh, we set up an LLC, 123 Main Street is going to take title. We need to have an amendment to the agreement of sale that says that 123 Main Street LLC is taking title to the property. Otherwise, the agreement of sale is not going to be consummated because the agreement calls for Mr. and Mrs. Smith, not 123 Main Street LLC. And then the title company will need to review copies of all of those entity documents. We'll have to review them to make sure the entity is permitted to own real estate and who is authorized to sign on behalf of the entity. So if your clients are going to take title to a property with an LLC, the LLC, the partnership agreements, or the corporation documents all have to say that that entity is authorized to hold property, to transfer property, and who is authorized to sign on behalf of the entity. A corporate resolution may be required. For instance, if the corporate documents or the LLC documents say only John Smith can sign as a member and John Smith is not available, we would need a corporate resolution to say the entity has gotten together and they've agreed that Mary Smith can sign the documents, or that both signatures aren't necessary, or we'd need a power of attorney to sign the documents. And that a power of attorney is a discussion for a whole nother day. That really is a very complicated legal document that people throw around like it's just, oh, we'll just get a power of attorney. Power of attorneys have very strict rules that must be followed and are really frowned upon by title companies. We do not like to use a power of attorney to sell property. We want to make sure that everybody that is selling the property is at the table. We can see them. We know that they're competent. We can make that judgment call. From the flip side, if it's the buyer with a power of attorney, we're not as concerned, but we want to make sure that we are ensuring entities that are allowed to take title and that the people who are encumbering the property with a mortgage are the people who are permitted to do so under the LLC documents, the partnership documents, or the corporation documents. So making that decision at the last minute, the day before closing, really hamstrings the title company because there are a lot of documents that need to be reviewed in order for the closing to proceed in a smooth fashion. Another entity that can take title is a trust. The title company also needs to review copies of the trust documents. We need to make sure that the trust is permitted to hold real estate and to sell real estate. We need to check if the trust is a revocable trust or an irrevocable trust. The mortgage company, if there's a mortgage, is going to want a revocable trust as opposed to an irrevocable trust. So a lot of clients will use a trust to avoid probate on the property because when the property owner dies, the property then transfers to the designated beneficiaries of the trust. So you can avoid going to probate if you have property in a trust. In most states, there are other legal and financial considerations when you put your property into the trust. So don't give legal advice. Tell your client to consult an attorney who practices in that area of trusts and estates. Every state is different in their inheritance laws and in whether they charge inheritance tax. Every state is different with what you need to do for probate. Many states have clawback provisions where if you've put it in a trust within a certain amount of time before the death occurs, it gets clawed back into the estate. So there's a ton of provisions that really need to be reviewed, and you need to check with legal counsel and make sure that it is set up in a way that it's how your clients intend the property to transfer. So that's business entities, that's trusts, and now we have when the buyers are natural persons, when it's Mr. and Mrs. Smith and they're taking title to the property. There are 3 basic ways that you can take title to the property. The first is tenancy in common. So tenancy in common is when 2 or more owners share ownership of the property, and it can be by equal or unequal percentages, but you need to specify that in the deed, which is why it's important to have that conversation before either the attorney or the title company has prepared the deed. So I have a closing on Friday where I have 5 siblings who have inherited a vacation home, and only 3 of the siblings want to keep it. And they don't want to keep it in equal shares. So the deed is going to go from the 5 beneficiaries to the 3 tenants in common. And 1 tenant is going to hold 50%, and the other 2 tenants are going to hold 25%. So the deed needs to specifically state that. And then the most important thing in that transaction and in all transactions when you're doing a tenancy in common is to have a tenancy in common agreement or an LLC type agreement. You need to have an agreement that says what the percentage is, are the common costs going to be shared by that percentage? Can they mortgage their interest in the property? Is there a right of first refusal? If one of them wants to sell the property, do the other tenants have the right to buy the property before it gets sold to some random third party? All of those decisions should be set forth in they call it a TIC agreement. They should all be discussed ahead of time because you could end up with a situation where 2 people own property and it's 50-50. One desperately needs money, so they mortgage their half of the property, and then they default on the mortgage. The mortgage gets foreclosed on, and then the company can sell it in foreclosure to another person or another entity, and suddenly that person who thought that they were going to be sharing a home or a property with their sibling or their partner is now sharing that property with somebody they met at the property the day they bought it. So most people aren't comfortable with that. You need to make sure that you address that in a tenants in common agreement. The biggest advantage to a tenancy in common agreement from an estate planning purpose is if a co-owner dies, then their interest can be transferred to their beneficiaries. So this is a common tool used. I see it mostly in second marriages. So if a husband and a wife that's a second marriage for both of them, they're buying the property together, but they each have children from the prior relationship, and they want their share in the property to go to their children and not to the other person's children. So they each want to kind of keep their estate planning separate so that one takes care of their children and the other takes care of their children. If you have a property in tenants in common, you can set that up so that when the wife dies, her children get that 50% interest in the property. When the husband dies, his children get it. Again, you want to have a tenancy in common agreement that would allow the surviving heirs or the surviving spouse to buy out the other party. So there's a lot of litigation. It has to be litigated in order to resolve it if it's not addressed in the tenancy in common agreement. So there's mechanisms in most states to force the sale of the property, but it can take a year or so to get that done, and it's also costly and expensive. And anytime you're dealing with litigation between family members, it's sad that that has to happen, and it tends to sour the relationship. So it's important, if you're going to take title as tenants in common, that you have a tenants in common agreement and you really talk about all of the things that could come up, whether, does it require unanimous consent to replace the roof, to replace the washer and dryer? Is there some amount of money that requires unanimous consent to be spent, or can you do up to $500 in repairs without the other person knowing, and then who shares in those costs? So it's tricky. It's like running a company. You really need to have your facts and your plan of action already laid out. So again, you can own it 50-50. You want to know if one party wants to see their interest, to sell their interest. Can either party mortgage the interest? Can a party rent out without their interest? How are maintenance addresses? All of those issues should be addressed prior to taking title to the property. Joint tenancy is where two owners own equal shares of the property, but when one co-owner dies, their share of the property transfers to the other joint tenants. So prior to 2015, or wherever, whatever state you're in that gay marriage was popular or was legal, this was a popular way for partners who had a long-term committed relationship to take title, because it most closely resembles tenants by the entirety. So it allows for, if one party dies, the other gets the property solely in their name. Again, this also avoids any probate proceedings because it's transfers automatically on death. You do need to file a new deed, because the deed would be to John and Paul, and you would want the deed to be just to Paul, who would survive by joint tenancy. Joint tenancy is different than tenants by the entirety because you have a 50-50 interest. But in joint tenancy, if one party has a lien against them, a judgment lien against them, it attaches to the property. So it's different than tenants by the entirety, where if you are married and you take by tenants by the entirety and the wife has a judgment lien against her, it does not attach to the property. With joint tenants, it does. So you need to be careful with that. And there's not much you can do to avoid that, but you need to be aware that joint tenancy will permit there to be liens on the property. If you're using it as I'm going to be a joint tenant and I'm going to then leave my spouse out of the will, in some states, and Pennsylvania is one of them, the spouse that's left out of the will can still file an action to take their elective share, which is up to a third of the value of the estate. So again, these are really kind of technical legal questions. The title company is going to ask them. They're going to basically explain the different forms of ownership. It's important that you understand them, and it's also important, some of the best advice a realtor can give their client is you need to see a real estate attorney in order to make sure that how you're taking title is how you actually want the property to be transferred. Because again, this joint tenants is a different form of ownership than tenants by the entirety, even though it allows it to be transferred upon death. Again, so the last one is tenants by the entirety. It is also in the 8 or so states that have community property laws. It's sometimes referred to as taking by community property. It requires that the parties be married. They take title as tenants by the entirety unless they specify otherwise. So a married person who wants to solely own their property, if they're married, they have to specify that they are taking this property as sole and separate owners. Otherwise, the spouse's interest in that property will attach 50-50. So you can take title as an individual, but you need to make it clear in the deed that you're doing that. Also, in some states, Pennsylvania being one of them, the mortgage and the deed have to match. So if you say, I want my spouse on the deed, but I don't want them on the mortgage company may agree with that, but you can't record the deed and the mortgage if they don't match. The flip is also true. If you are taking title and you're married and you want, the husband wants to have the property as sole and separate, but his wife's got much better credit, so he wants her on the mortgage. Again, you can't do that. The mortgage and the deed have to match. So you need to check your state, see how it's going to be reflected. And then if you want anything except tenants by the entirety, if you're a married couple, you need to specify that specifically. So just a quick slide on marital property rights. It varies greatly from state to state. It's important to know what any state that you're working in or dabbling in. Is it a community property state? A community property state, California being probably the most populated one. Anything that is acquired during the marriage is split 50-50. Period, end of sentence. So it's difficult to segregate your real estate, your pension, your insurance benefits. In California, it's community property split 50-50. It used to be a question as to whether same-sex marriages were legally recognized. They are now for the last 10 years. There are some ancient laws of dowry and courtesy that may be in effect in some states that impact whether the spouse has an interest in the other spouse's property and at what point does that interest occur. So if a wife owned property before she got married and then she married, it would automatically, the law would recognize in most states that have tenants by the entirety that they own it as tenancy by the entirety. But some states will take into account the fact that the wife owned the property beforehand and the husband then would only be entitled in a divorce, the husband would only be entitled to any appreciation that occurred during the time that he was married to her. So he doesn't get the whole 50-50. He only gets whatever appreciation occurred during the term of their marriage. The question needs to be asked about whether they both need to be on the deed and the mortgage and how does that work. Again, taking by tenants by the entirety, the property is not divisible by judgment liens, which means if if the one spouse has judgment liens, they won't attach to the property. With tenants by the entirety, you can't do anything but 50-50. It's got to be a 50-50 split. So if you want a 25-75 split because one partner makes significantly more money than the other and they've agreed that they're going to keep their finances separately, their best way to take title then would be as either tenants in common or joint tenants with right of survivorship, because the law with tenants by the entirety will assume that it's a 50-50 split. Um, so that's only it's a half an hour. I'm sorry, but I'm hoping that that raised a lot of questions, and we can go through some questions that you may have with your clients. Does anybody have any questions?
I do.
Sure. What?
What is the code, the Virginia code that explains everything that you just what could I refer somebody to? Of course, the attorney, but if I wanted to check into this a little bit more, what is Virginia code?
I don't know off the top of my head, but I can send you an email with it.
Wonderful, thank you.
Does anybody else in another state want to know um, what what laws to refer to for this?
Yes, please. I'm in Florida. If you could
Sure.
help me by any chance, Elizabeth, that would be great. It's really easy on our contracts to choose that they may assign but not be released from liability of the contract so that my buyers can figure that out how they want to take title during that process while we're going through the transaction. But I'm curious, it sounds to me like the title companies really know a lot, but should we have them be consulting attorneys also, like estate planners and things? For some of this is pretty intricate.
Some of it can be very intricate, and yes, it's always a good idea to, I'm also an attorney, so I'm a little biased that I think that everyone should go and talk to an attorney. And if I
Yeah.
sounded very technical and like the title company knows a
Yeah.
lot of title companies might not know as much as I do because I am also an attorney. So
Yeah, that makes sense.
that makes it a little bit more legal. I'm a little bit more comfortable talking about those concepts, although I do sit in on some of my title agents' closings that I'm impressed with the level of knowledge that they have. But in a state that doesn't typically use attorneys like Pennsylvania, Pennsylvania doesn't even offer that in the agreement of sale as an option as to how you want to take title. So that question has to be asked.
Hmm.
In New Jersey, they have it's a kind of an attorney state where they have a 3-day attorney review period. You can cancel your contract anytime within the first 3 days for any reason or no reason at all. But the assumption is it's called the attorney review period that you will go and get an attorney to review it. The attorney at that point should be asking that question. I know when I started practicing law for the first time in New Jersey. I was licensed in New Jersey, PA, and New York, but I was practicing in New Jersey, and I was a very young green associate, and so I got a lot of the contracts for attorney review. And at that time, gay marriage wasn't recognized, but there was the town that I was in was a very gay friendly town, and a lot of partners were buying property and didn't know any of these questions. And I'd sit down and ask them during the attorney review period, how do you plan on taking title to the property, and explain them to them. And they were mostly all first time home buyers. They were young. They didn't know. They were just like, oh my gosh, there's so much to think about. We're going to have to go back and talk about this. We'll talk to our parents. We'll see what we're going to do. And it was interesting because then I got so many clients from that because they would go and talk to their friends and they would be like, "Oh, you got to go to this attorney. She'll explain to you what you need to do." And everybody's different. Some people have their parents helping them and they want, their parents are going to give them gift money, but the parents want to be on the deed. How does that work if, all of a sudden you've got a mom and a dad and a partner owning the property because a partner passed away? So they're hard discussions to have, and you're kind of a killjoy when you're talking to them about it because most of it is kind of estate related. It's what happens when you die, which is the last thing a young couple buying a house for the first time wants to think about. But you have to think about it. And when you don't think about it, you could really make a bad mistake. And as you get older and you're doing more estate planning and you're thinking, I'm going to put it in a trust, that's another issue because you there are issues with regards to trust and if you put it into an irrevocable trust, you can't make any changes to an irrevocable trust. So you could put it in an irrevocable trust and have your 3 children as the beneficiaries and then have a fallout with one of your children, and you'd want to redo it and only have 2 children as the beneficiaries. And if you've got an irrevocable trust, you cannot do that. So there are a lot of questions that need to be answered. So it's a lot of people want the Virginia code, so I will send that. Kristen, do you know if there's some way that I could add that to the presentation at the end before you put it on YouTube?
Um, I don't know, Elizabeth. I typically don't put like the chat, right? So
If you have a link or something, or a blurb that she can add into the description, that might help.
oh, I can totally do that. Yeah, when I like on our description on our YouTube page, I can put it in there, Elizabeth, if you're comfortable having it
Great.
be there.
Yeah, I'll put the Virginia code and the Florida code there.
Okay.
And
And
I
then
see
Brendan
Brendan
had
has a
some.
question. Do mortgage companies prefer revocable trusts due to the ease of transfer and rewritability? Absolutely. So, and I I can't remember the last time I saw an irrevocable trust. They're
Gotcha. Thank you. I was
90%.
working with one of those. I wanted to advise on that. So appreciate touching base on that.
Yeah, the revocable trust is definitely standard. And we get a lot of clients pushing back saying they don't want us to see a copy of the trust, but we have to see a copy of the trust. And if there's something particularly sensitive that you want to redact, you can, but for the most part, I want to know who I'm insuring and what it is, and particularly important if the seller is a trust, because we're insuring title for your buyer. We need to make sure that the seller has good title and that they can sell it, that they have the right to do that, and that I've got all the right people signing off on it. Um, so if you title property under an LLC in California, the LLC documents control, not the community property state. The LLC would own it. The membership in the LLC may be subject to community property, but the transferability would be subject to the LLC requirements in California.
Okay, great. Yeah, I figured it was something along those lines, just because the LLC structure might override that.
Yes, yeah, if you intentionally take property in the form of an LLC, that would control how it is devised and whatever the LLC documents say with regard to how you take title. So you might want to have in your LLC documents the 25-75 split, because one partner is putting more money in, their capital contribution is 75% and the other partner is 25%. Regardless of their marital status, that 75-25 would control, because that was the capital contribution that those parties made to the LLC. That makes sense, right?
Yeah, absolutely. Thank you. I appreciate you clarifying that. Thank you.
Any other questions? It's really been and it's interesting to sit at a table. Particularly, I love, and I think everybody does. We all love that first time home buyer. They're just so, full of energy and they're so excited. And I had a couple that was buying a house and they weren't married. They were engaged, but they're not getting married until fall of 2026. We spent a little bit of time talking about are you going to take title? What happens in the next year and a half? Um, what are you thinking? What is your goal? How do you want to deal with that? And it's an important conversation to have. Um, sometimes the one party will buy it ahead of time and then add the spouse once they get married. And even that's a question. And do I need to add my spouse to the deed? Is there a transfer tax implication to that? In most states, you can add a spouse or take a spouse away without having to pay transfer tax. But in some states, that might be a consideration. Is there additional costs incurred to add or take away a person from the deed? And that's a question that you want to ask ahead of time as well. So, Kristen, I think what I'll do in addition to the Virginia code, I have a cheat sheet on properties state by state.
Okay.
So I can put that in, and then everybody from any state, from Georgia to Portland, Oregon, will be able to figure out
Yeah,
what the laws are. They're
yeah, so what
fairly
we can do is
standard, those types of ownership across the country, as far as what the joint tenants, tenants in common, and tenants by the entirety mean. But again, every state it's got a little nuance that's important to know.
So maybe what I can do is we can put the, I can put it also on the YouTube page, but I can also link it in Slack as well. That way it's easily accessible for
Perfect.
everyone in one place. So just send that to me and we'll make sure everyone gets it.
Great.
Awesome. Thank you, Elizabeth. Does anybody else have any questions? No? Okay, I'm going to stop recording.